meeting, we would be receiving an overview of the Department of Justice and Correctional Services and all other entities from the Minister. It will be followed by the presentation by the Office of the Chief Justice. I would like to plead with everybody that we've got serious time constraints. We must be finished by 12 o'clock. So let's try and be very focused. We did indicate to other entities that will be presenting to us that a presentation must not be more than 30 minutes because we have gone through the presentations so that we allow space for interaction. Once again, welcome Minister, Deputy Ministers, and all honorable members and everybody on the virtual platform. Over to you, Minister.
Thank you very much, Chairperson. The Deputy Minister of Correctional Services, Nkosi Holomisa, the Deputy Minister of Justice and Constitutional Development, John Jeffrey, the Honorable Chairperson of the committee, the National Commissioner for Correctional Services, Mr. Bulelani Magwanishe, Mr. Samuel Tovakale, sorry, Chairperson, the Director General of the Department of Justice and Constitutional Development, Advocate Doc Mashabane, the Secretary General of the Office of the Chief Justice, and the National Director of Public Prosecution, the Legal Aid Board, and all members of the Portfolio Committee. It is indeed an honor for us to be here this morning to continue to account to this August House. Honorable Chairperson, the performance of departments in our portfolio has continued to improve during this MTSF period. For example, the Department of Correctional Services is no longer synonymous with the negative audit outcomes. The NPA is gradually regaining its foot. Legal Aid South Africa continues to be a beacon of hope on accountability and good governance year in and year out. They continue to obtain clean audit outcomes. We acknowledge that there are still challenges in our portfolio, but we don't sweep this under the carpet. When we appointed to this portfolio, the performance of the Department of Justice and Constitutional Development stood at a worrying 50%. Today, as we account to this portfolio committee, the department's performance has improved to 80%. While this is a significant improvement, the department will continue implementing measures to make more impact on service delivery. Yes, we are disappointed with complaints we continue to receive from our people when they interact with the master's office. We commit ourselves to turn the situation around in addressing the systematic challenges in the master's offices countrywide. We commit ourselves to turn around this situation for the benefit of the people. In this regard, the department will outline the progress made in the modernization and digitization to date, which is aimed to resolve some of the systematic challenges that the master's office continues to face. Among some of the priorities for the 2023-2024 financial year, the department will be focusing on the modernized and the digitized justice service platforms, increase access to justice services, transform state legal services, and transform legal profession. Improved and transform master services and advance constitutionalism, human rights, and the rule of law. We will hasten our fight against the scourge of gender-based violence and femicide in the new financial year. We will develop phase 6 of the femicide ensure finalization 1% of the Child Justice Act in Parliament. The transformation of the legal professions remains the priority of the Department of Justice and Constitutional Development. In the new financial year, we will allocate 83% of value of briefs to previously disadvantaged individuals, legal practitioners, 28% value of briefs to female legal practitioners, and 40% briefs to female legal practitioners. And in the previous financial year, Honorable Chairperson, our commitment to this transformation can be seen through the value of the briefs that went to previously disadvantaged legal practitioners. As honorable members are aware, our extradition request for Atul and Rajay Gupta from the UAE was dismissed based on technicalities and inexplicable reasons. I've been in contact with my UAE counterpart and met the UAE representative in South Africa and registered our country's displeasure. We will soon announce the way forward with regards to this matter upon finalization of our engagements with our UAE counterparts. Our view remains that we have complied with all the requirements of the extradition treaty between South Africa and the UAE. And in this regard, there was no basis for dismissing our application. But we will deal with all the aspects as and when we finalize the discussions between ourselves and the UAE on the matter. Out of respect for the NPA's prosecutorial independence, the NPA will be able to explain matters related to the Section 174 Nolane matter discharge that I believe honorable members are aware of. It has been widely reported in the media. On the extradition of the two fugitives, Ms. Shepard Bushiri, Mr. Shepard Bushiri, his real name, Mr. Shipiliro Kama, and his wife, Ms. Mary Bushiri. State law enforcement officials will travel to Malawi to testify in their hearing on a set list of questions. In Malawi, the prosecuting authority of Malawi has been updating us regularly on this matter, and the central authority. They have been updating their counterparts, the NPA, and the central authority have been updating our central authority in South Africa. And where there were decisions to appeal matters in Malawi on the matter, it was joint decisions between the central authority and the authority in Malawi, and where the NPA, where the prosecuting authority of South Africa and the prosecuting authority of Malawi needed, they also agreed on a strategy and a way forward. And up to so far, we believe that the matter has reached a stage where the officials will be deployed to attend to the hearing and to testify as and when the court date is set, which we are still awaiting from the Malawian authorities. South Africa is a party to the Rome Statute of the International Criminal Court, which it ratified on the 27th of November 2000. A central feature of the Rome Statute of the ICC is that state parties to the ICC are encouraged to investigate and prosecute ICC crimes domestically. South Africa also domesticated the Rome Statutes through the adoption of the implementation of the Rome Statutes of the International Criminal Court Act 2002, which is referred to as the Implementation Act, thus affirming its commitment to an international justice system. South Africans remain committed to fighting impunity for gross violations of human rights and crimes against humanity, wherever it occurs by whatsoever means and whoever commits it. International law itself recognizes the sovereign rights of states to determine their domestic legal system and the obligations that they are willing to voluntarily carry through ratifying international treaties or exiting where no longer convenient to subscribe to them. Being party to the Rome Statutes means that South African government has an obligation to cooperate fully with the ICC by surrendering suspects against whom a warrant of arrest has been issued, providing legal assistance in investigation and obtaining evidence. Honorable members will remember that on the basis of the governing party's resolutions, the ANC, with regards to the ICC, that reads as follows: noting the ANC's previous positions on the international approach, signaling countries of the continent, withdrawal and robust engagements have positively impacted and contributed to the ICC being substantively reformed for the better. Further, noting that only a few countries in our continents have ratified the Malabo Protocol, thus delaying the establishment of the African Court of Justice and Human Rights. The ANC and the South African government must rescind the withdrawal from the ICC court and intensify its lobby for the ratification of the Malabo Protocol. Guided by the above resolutions, I proceeded to withdraw the bill that was aimed to repeal the implementation of the Act of the Rome Statutes. We agree with the Amnesty International in its annual report that the inconsistency of the ICC in the execution of its work undermines the rule of law and the work of the court itself. The fact that an investigation into the atrocities in Palestine that was opened long before the Ukraine investigation has not yet been completed, and the ICC is citing financial constraints, while member states and everyone was willing to quickly find the resources to investigate and refer on the matter of Ukraine, is clear double standards in the application of the law. And this does not help with fairness and also with the rule of law across the globe. The people of Palestine must find justice in the ICC like any other citizen of the globe. The issuing of the arrest warrant by the ICC against the Russian sitting president has brought the issue of the ICC again into the public domain. We are looking at all options in this regard, Honorable Chairperson, including to look into the bill that may amend the implementation of the Act so as to bring it in line with international customary law, such as that is practiced in the Great Britain and in Holland, where the executive has the power to exit or suspend the implementation of the statute where it is not in the national interest to continue with its implementation. The National Prosecuting Authority has been successfully returned to a period of institutional growth and stability. Since the inception of the NPA, the DPCI task force, the ID has thus far declared 89 investigations and enrolled 32 cases involving 187 accused persons. The AFU has secured freezing preservation orders to the value of 12.9 billion rands and recoveries to the value of 2.9 billion rands, inclusive of the ABB landmark reparation case. The NPA continues to contribute towards increased safety in South Africa. The quote is 60% and convict 50%. In 20
Chairperson.
Yeah, is 300. And the
Chairperson, sorry, I'm not sure if everyone else is struggling to hear the minister.
Yes, Minister, I think your bandwidth is very low. Maybe you must switch off the video.
Mr. Chair, the Minister must please repeat this last bit about the NPA because his connection was so bad that I couldn't hear it and it's important.
Yes. Minister, can you repeat the last paragraph on the NPA?
Is it better now?
Yes, better.
Can you hear me now?
Yes.
Oh, okay.
Now that we can't see him, it's much better.
I'm surprised, Chairperson, because I'm a very handsome man. The NPA...
in your own view.
The NPA continues to contribute towards increased and security in South Africa through effective prosecutions conducted. The conviction rates in the High Court for the 2022-2023 financial year is 87%. Regional Court 74%, Court 88%, convicted in cable theft cases is 80%. The number of persons convicted of corruption and or offenses related to corruption in 2022-2023 financial year is 334, and the conviction rate in complex commercial crime is 85.5%. A new expungement procedure, Chairperson, that has become a space of a huge public space on expansion. Those who are denied opportunity are putting a lot of
connection is very bad. I'm only hearing every third word, and this is all very important stuff.
Yeah, maybe Chairperson, let me try to reconnect.
Yes, please do.
Am I the only one who can't hear a thing, Mr. Chairman?
Chairperson, I'm back now. Is it better now? I've tried to find a different.
Let's proceed, we will see.
I'm just trying to get where it was. You will advise, Chairperson, if it's still difficult, then I will try another means again.
No, it's still clear for now.
Oh, okay, thank you. With regards to the expungement of a criminal record, those who are denied opportunities after failing to expunge their criminal records must know that we are putting a lot of focus on this area of our work. Last year, we received up to 20,000 expungement applications, which we processed. South Africans from all walks of life can apply for expungements of their criminal record in terms of the Criminal Procedure Act of 1977. And this service, Chairperson, is free of charge. We don't charge anyone for this service. To the Director General of the Department of Justice and Constitutional Development, that is where they apply. Anyone can apply to have his or a criminal record expunged when, amongst other considerations, a period of 10 years has passed after the date of the conviction for that offense. One has not been convicted and sentenced to a period of imprisonment without the option of a fine during those 10 years. The sentence was a fine not exceeding 20,000 rands. The sentence was an imprisonment with the option to pay a fine not more than 20,000 rand instead of serving the period of imprisonment. The sentence of imprisonment was suspended wholly. The sentence was a correctional supervision in terms of section 276(1)(h) of the Act. We acknowledge that more still needs to be done on the expandment. Therefore, we will conduct more awareness campaigns for this process and also capacitate the relevant unit. The Special Investigation Unit continues to recover millions of rands and probe various allegations of corruption and maladministration. Our support to the unit will be extended further in the new financial year. The Constitutional Court has given impetus to the work of the SIU in the Lidler judgment. The judgment has resolved the issue relating to the jurisdictions of the Special Tribunal, whether it can adjudicate and determine the legality of contract entered into by state institution and any other decisions by the state institution. The Constitutional Court has ruled that the Special Tribunal has the jurisdiction to adjudicate and determine the legality applications. This will enable the SIU to continue to refer questionable contracts to the tribunal. The Office of the Chief Justice will continue to improve access to justice for all South Africans from all walks of life. Amid the power outages in the country as a result of load shedding, we are working towards ensuring that courts are not disrupted. The Constitutional Court and the Supreme Court of Appeal are not affected by load shedding. We have also rolled out generators to various high courts across the country. Under Correctional Services Chairperson, the performance of the Department of Correctional Services has been improving since we were appointed to the portfolio, from the 70% in the 2020-2021 financial year, 80% 2021-22 financial year, to 89% in the 2022-23 financial year. We have also recorded successive and qualified audit opinions in the last 2 financial years. We will ensure that the Department of Correctional Services obtains a clean audit during our term of office. And this is our last year, Chairperson. So we endeavor to achieve that. Honorable Chairperson and esteemed members, we want to assure this portfolio committee that inmates are incarcerated securely and in inhuman conditions. In the 2021-22 financial year, we had 22 escapes from a total of 143,223 inmates population. We are the first to acknowledge that one escape at our facilities is one too many. We will redouble our security operations to prevent escapes and deal harshly with officials who fail to adhere to standard operating procedures. As the National Commissioner had acted yesterday in the Mthatha management area, where on duty, where there was an escape of 2 inmates and 1 has been recaptured. 8 officials who were on duty on the date of the escape and did not adhere to the standard operating procedure have been suspended, and they will undergo disciplinary processes. Correctional Services performance, as I said, is continuing to improve, and we continue to monitor adherence to our standard operating procedure. Inmates are not sitting idly in their cells. Others are busy with infrastructure projects, among others building pharmacies at their own centers, houses for the victims of crime, renovating public infrastructure, producing own food in our farms and gardens, creating vegetables gardens in schools located at disadvantaged areas, thus contributing towards the fight against hunger and poverty. And in the process, they also learn valuable skills for themselves as and when they are released back into the community. As esteemed members are well aware, as a result of the oversight visits that this portfolio committee has conducted at correctional service management areas, all our centers are implementing the self-sufficiency strategic framework. Through this framework, government has saved a total of 372 million rands in the last 3 financial years. We will continue to save more money through the self-sustainability framework, as 70% of our inmates will be hard at work to improve performance at our farms in the new financial year and in the workshops. This department continue to be entrepreneurial. We have also impressed upon the department to prioritize victim empowerment in their operations. This is not our sole responsibility. We will collaborate with other sister departments to ensure that victims of crime are indeed empowered. We will also increase the number of victims who participate in restorative justice programs in the new financial year. Plans are also afoot to collaborate with the Faculty of Criminology and Criminal Justice at the University of Limpopo. Honorable Chairperson, the Department of Correctional Services continues to be in the news following the escape from lawful custody of rapist and murderer Thabo Bester at the Mangaung Private Correctional Center and his rearrest in Tanzania. Bester is currently incarcerated at the secure Pushimampurisi maximum facility. He will be appearing with his co-accused on the 16th of May 2023 in Bloemfontein. The South African Police Services continue to make several arrests related to this matter. The Department of Correctional Services has this morning served the Mangaung Correctional Services Pty private company with a notice to terminate. The notice to terminate follows that DCS had sought a legal opinion and it has been deemed that BCC is not suitable to continue with the contract. In line with the concession contract agreement, a termination notice of a period of 90 days has been served to the BCC, and thereafter, the contract will cease to operate. DCS has already resumed with an internal exercise for the takeover process. And this will have to happen after the 90 days period in terms of the notice to terminate. Chairperson and esteemed members, relevant departments and entities under the ministry will present detailed plans for the 2023-2024 financial year. We are hard at work to create a better life for all our people and make South Africa great. As you will have seen, there is steady improvement in all the departments' performance. While challenges continues to come, we confront them head on. And we believe that the challenges should not bog us down, neither discourage us, but they should strengthen us to continue to do our work to improve the performance of all the departments under the ministry and this portfolio committee. Thank you very much, Honorable Chairperson.
Thank you very much, Minister, also for sticking to the time allocated. Thank you very much. I hope you have set an example to all others who will be making their presentations. Thank you very much. Members, can I note hands? I have Honorable Maseko Jele. Can I note hands for questions to the Minister before we move to the Office of the Chief Justice? Let's start with Honorable Maseko Jele, followed by Honorable Swart, Honorable Horn, in that order.
Thank you, Chair. Good morning, Chairperson and the Minister and the team and colleagues. Chair, can I apologize? I've not changed my picture here, and I'm still here in the village so that I can not show my picture myself. Thank you, Chair. I only have 3 questions, Chair, because of time. Minister, thank you very much for the progress and at least the good work that showing progress in the department. The only thing that maybe I would like the Minister that can just touch on it in his response, Chair, it is the issue of modernization. We still the update on that matter. I won't get into details if you can give us progress on that area. And then the other one, Chair, when we started, we requested, I mean, when we started the term, we requested that those apartheid laws that may still be seen being a hindrance in our progress to democracy, to intensifying democracy. Do we still have those laws that might maybe we still have to deal with them, Minister. If we have, maybe can you give us a briefing as to those laws? And then the last one, Chair, it is on the issue of, yes, on our tour oversight, we have seen the good and the bad, Minister, particularly if I can make an example on the issues of security. If you check on the side of the Northern and in other areas, but particularly on the Northern Cape, and issues of infrastructure, and also the issue of intensification of community services issues when it comes to access to justice. If maybe, Chair, I would request the Minister that even if it does not have maybe a consolidated answers on this one, but I would request the Minister to, when he goes back, Chair, if he can also look into those issues so that when the department comes, at least he would have touched on those issues. But lastly, Chair, I just want to thank the Minister for also highlighting the issue of expungement, because it is a problem. Our communities don't know about this, Minister. If really you can intensify your campaigns on this area, I think it will be very, very good for our community. Thank you, Chair.
Thank you very much, Honorable Swart.
No, thank you, Chair, and morning to Minister and colleagues. I do appreciate the Minister's input and the improvement in the department. However, when one is on the ground, obviously one does receive many, many complaints, and we'll be touching on some of those aspects, particularly when it comes to the Master's Office. We'll be engaging with those issues. Also, when it comes to the ongoing complaints of maintenance, domestic violence, these are very, very critical. And whilst we appreciate that there are officials doing their very, very best, there are obviously issues here that do require improvements. And I must say, I was heartened when we visited the High Court in Kimberley and the Magistrates Court in Colesberg. Whilst there are many other areas that have great challenges, we were very impressed with some of the facilities that we saw there. I appreciate also what you've indicated about load shedding and the reduction of the impact of load shedding at courts, then so that we can ensure justice is provided. Minister, I'd like you to unpack a little bit the issue of the termination of that contract. Now, I appreciate that's on the correctional services contract. I appreciate you issued a notice today and that there'll probably be litigation about that, but maybe you could just touch upon that. And then the issue of the extradition, you did indicate the Gupta extradition in particular. You indicated, and I'm sure we all agree with you, we were deeply disappointed at the decision by the UAE, and we welcome your engagement on that issue. But maybe you could just explain, touch on a way forward. Is there a possibility of appeal process? One of the general issues that one is faced with as a member of parliament is the perceived fact that there seems to be increasing, and there is increasing criminality, and particularly when it comes to criminal syndicates. And whilst the NPA will address this together with their investigation, their prosecutions, and obviously the Hawks are the investigatory body, I think the main concern arises with the increases when you look at the construction industry, construction mafia, when you look at the mining industry, Zamazamas impacting. There are recent articles about that. When one looks at Eskom, load shedding, the impact of corruption and criminal syndicates, despite what the Minister of Electricity might say, that it's not an impact. We know it is an impact. The impact of at other SOEs such as Transnet. This is a great concern, and maybe you can unpack a little bit about that, or we will deal with that later. And lastly, Chair, I just want to express my deepest concern that the Minister equates the possible ICC referral of Ukraine and the Russian President Putin with the issue in Palestine. I think it's totally unacceptable with the issue with Israel, and I believe that the ANC government should relook at its foreign policy, which is often described as clueless and immoral, and also consider gross human rights violations such as in Iran, China, North Korea, Burundi, Syria, where the ANC government has consistently taken a wrong side when it comes to voting. But that is a separate issue. It's a foreign policy issue. But I felt I just want to express my deepest concern in that regard, following the Minister's comments. Thank you, Chair.
Thank you very much, Honorable Horn.
Thank you, Chair, and good morning from my side. And thank you to the Minister for the briefing. Chair, I will also try and limit my questions and maybe park some others to the departments who are to follow, given our time constraints. Minister, the first question I want to ask, and that's taking us back to the 3rd of May, 1 year short of a full year, when you did your previous briefing to this portfolio committee. And there you gave a firm undertaking that the cabinet will deal with the issue of the final court administration model within the then financial year. Today, you're silent of it, and neither this committee nor the public at large has been appraised as to whether there's been any progress. It's a matter that's been coming now for more than a decade, and I would want to plead with you to bring us up to date as to whether there's been any progress, and if not, what is hampering this. Then on correctional services, one issue I think needs to be addressed as well, and that is the issue that the management of overcrowding now seems to be resting solely on concessions given to sentenced inmates and releasing them before they really qualify for parole by way of presidential decisions. This committee has expressed a view that can't be the permanent solution. But if one considers that your build program in respect of additional bed spaces has more or less grinded to a halt, we must be very worried about it. We have been informed now again that the Parys build of the new correctional centers also once again, as is the tradition with correctional services, come to an halt because of issues with the contractor. So I want to hear from you what is the way forward in terms of the capital works program and specifically the build program of correctional services, or are we just to make peace with the fact that this is a constant issue? Then, Chair, on the legislative program, this time last year, the Minister, again, as has become sort of a tradition, informed us that the lower courts bill was to be introduced. Yet we've now been informed that it's being put on ice and on the back burner yet again. What is the reasons, and what is the progress, if any, with the finalization of that specific bill? And then on the Department of Justice's side, the court recording technology issue, I think we need to be updated regarding that. When we were now on oversight, informal information was to the effect that the current interim contract has now been extended with another 2 years. Is that correct? And what is if not, what is then the status of a new award in order to prevent the type of really the prevention of court operations, really because of a lack of court recording technology. Then when we were now on oversight again, the committee was brought under a very clear impression that the fallout of the hack, and specifically the impact thereof on the efficiency and the speed of the online systems of the Department of Justice is not yet settled. So we need an update from the Minister as to the medium and long-term plans to address specifically the efficiency of systems and the speed of the online systems. the master of the High Court didn't mince his words by saying that since the hack at master services, but by extension all other services of the department is really only there in theory for most parts of an ordinary work week. And then maybe lastly, in line with that, Chair, one must say to the minister and would want a response from him. I don't think it can be left to the department any longer to deal with that the need for an updated, transparent list around court infrastructure and the maintenance thereof is now urgent. I know the minister has previously said that the department is in a process of finalizing an updated priority list and an assessment list. I think the minister also owes us an answer as to the progress with that project. Thank you.
Thank you very much. Before we move to Honorable Breitenbach, the minister advised me that he was kicked off for some time, so he could not hear part of what Honorable Swart asked. So what I propose we do after Honorable Breitenbach, I will ask Honorable Swart just to repeat the questions, not the other thing, not the preamble, but just the questions so that the minister can be able to capture the questions that we asked.
Chairperson, maybe before the committee waste time, I heard most of the time, most of the issues he raised. I just did not get the final issue. Where it kicked me out is when he was speaking about increasing criminality. That's where it kicked me out.
Okay. So I think after Honorable Breitenbach, we will ask Honorable Swart just to repeat that part. Honorable Breitenbach.
Thank you, Honourable Chairperson, and good morning to everybody. I will keep my questions very short as a result of our time constraints, and I'll take them up with the Minister on a different platform. What I would like to know is what progress, if any, is being made with the integrated criminal justice system. How many billions we've poured into that bucket with a hole in the bottom. It seems to be going absolutely nowhere. We hear about it year upon year upon year, and there's just no progress, no improvement. I want to know how much money has been spent on it to date, and what is the current situation. Then I just have one or two issues that I want to take up with the minister here, and so you know, to say that the Master's Office is improving progressively is just, it's simply not true, Mr. Minister, and I think you're aware of that. The Master's Office has gone from being completely dysfunctional to a train wreck. It doesn't work. It doesn't satisfy anybody's requirements anywhere in the Republic. Nobody can get anything done. Everything is a backlog. The filing systems are chaotic, to say the very least. And just a couple of weeks ago, the Cape Town Master's Office sent out a letter to anyone who was interested, telling them they'd limited their business hours to 1 or 2 days a week. No consultation, no warning. What have you done about that, and why is it acceptable? Then the minister deftly sidestepped anything about the Steinhoff issue. Of course, we'll take this up with the National Prosecuting Authority when they come. But the minister's views, please, on why the Steinhoff matter is showing absolutely no progress after all this time, when it's really not that complicated a matter to get into court. And to suggest that the National Prosecuting Authority is finding its footing, well, I strongly disagree. And recent events, I think, support my view, not yours. The rather embarrassing flip-flop of the country on the ICC, perhaps you could just tell us how that happened. I'd be interested for you to tell us how that happened. We withdraw, and then we don't withdraw, all within the space of 3 nanoseconds. And then the minister's views on Israel are quite illuminating. He chooses to pick on a country smaller than the Kruger National Park, a speck in the desert, to spend 10 minutes telling us how dreadful they are. when human rights abuses may or may not occur there, and nobody says Israel is perfect, not by a long shot. But in the rest of the world, serious human rights abuses occur also in Africa and elsewhere in the world, as mentioned by Mr. Swart. The minister chooses to remain silent on those. And to compare what the Israel and Palestine situation with the Ukraine and Russia, really, you know, even you, Minister, should know better. So I disagree strongly with your views, and I find them quite petty and somewhat puerile. Thank you.
Thank you very much, Honorable Reitenbach. Honorable Swart, can you repeat your last paragraph?
Yes, Chair, I'll be very brief. Minister, I was referring to increased criminality when one has regard to the construction mafia, the mining zamazamas, with mining companies saying criminal justice system is failing them, and at SOEs such as Eskom, Transnet, and other SOEs where the operation of criminal syndicate seems to be on the increase, despite what the Minister of Electricity indicated. And I know we'll raise these issues with the MPA, but you might want to comment on that. I also made comments about Israel, expressing my displeasure, which I don't expect any response from you, as it is a foreign policy issue, but I also expressed my displeasure with your comments in that regard. Thank you, Chair.
Thank you very much, Honorable Swart. Over to you, Honorable Minister. Honorable Minister.
Thank you very much, Chairperson, and I'm very glad with them. Thank you to all honorable members for their feedback. The first question relates to the issue of modernization, and with regards to the IJS project, I can confirm, Honorable Chairperson, that a lot of progress has been made with regards to the IJS and also its governance. It is also, there is a system developed called PVA, aimed to connect police stations with the NPA and the courts across the country. And also there are various projects from departments of Home Affairs, police, and so forth that are also improving in this regard. It's an integrated solution. And it's not all of it the money of the Department of Justice, but it's monies of various state departments, which we are coordinating to create and integrate the system so that we're able to resolve some of the matters that we're dealing with. And I think the Thabo Bester matter is reflected and shown that if we can be able to integrate the system in terms of personal identification, in terms of the fingerprint systems, in terms of the DNA, Home Affairs, Justice, and Police, a lot of criminality can be averted in this country. So that is what we are continuing to work towards. And an amount since its inception, this project has been there for more than 10 years, 15 years or so. So there's been about 7 billion rand that has been spent in this project, as Honorable Bradenbach is asking. And this has not been in one financial year, but many financial years. And we have learned also across the group, Honorable Chairperson, that the modernization projects can sometimes take time, and they need the buy-in of all the relevant people and stakeholders. And in this regard, we are working to ensure that all the government departments work with us to consolidate and ensure that this indeed becomes a success. And there are challenges which we will not shy away from, as pointed out by honorable members. And those challenges, as and when they arise, including governance issues, including to get value for money, we confront them through the governance structures where we are looking at. The issue of a consolidated infrastructure program that the Honorable Jelle asked about, including Honorable Horn. Indeed, we continue to engage with public works with regards to the issue of infrastructure. for both departments, which is a huge challenge for us, because our infrastructure projects continue to underspend and they are not moving. But both departments are now at a stage where they've also on their own been able to identify implementing agencies that, as per the agreement with Public Works, and also to devolve some of the powers to both departments to be able to deal with some of the infrastructure challenges. And I think when the committee calls us to deal with this matter with Public Works, we'll be able to unpack more, because I know that the committee is intending to do that. That last meeting was postponed. Indeed, the apartheid era project continues, and this financial year we are looking at about 3 laws that we will be bringing through the process. The only difficulty is that they may not be processed before the end of this financial year or term, but we will be able to table those bills aimed at amending some of this apartheid era legislation. With regards to the complaints to the master, I agree with Honorable Swart. We also continue to receive such complaints. I think Honorable Bredenbach also raised the same issue. We are of the firm view that the only way to improve the services in the master's office is through rapid modernization and digitization, which we have now invested a lot in. And I do think that before the end of this financial year, the honorable members will see the change in services in this space because of the work that is it's ongoing in that space in terms of modernization and the digitization of the master's platform. We do believe that we'll be able to turn it around and be able to provide the services on time with regards to the letters of executorship and so forth in real time. Honorable Swart asked also about the issue of the termination of the contract with the MCC, the Mangaung Management Facility. Indeed, we have received the legal opinion, which does show that the systematic challenges that were faced with the MCC over a number of years, including the last one with regards to the escape, points to the fact that the management contract or the concession contract cannot continue in this kind of a format, because indeed they are struggling to meet the contractual obligations. Therefore, the department has decided and issued a notice of termination to the Mangaung Management Company with regards to this matter. And we will prefer to leave it there because it's an area where of uncertainty in terms of issues of litigations and so forth. But suffice to say that indeed that notice has been served this morning. With regards to the extraditions of the Guptas, indeed, it's a matter that we continue to engage with our counterparts in the UAE. And during my discussion with the Minister of Justice in the UAE, he revealed that this matter cannot be appealed because the decision is of the appeal court in the UAE. The only way forward could be a resubmission. And they committed at this stage that they will look at the expedited processes. But these are still issues that we are engaging with themselves, with the central authority, and also with the NPA in terms of the issues that or matters of resubmission if it is still necessary. And as you'll be aware, the other issue relates to the fact that where are they still in the UAE or not? But for us, this is the last country they were last seen it officially in, so we will deal with them as if they are still in the UAE because that was the last country of sight. With regards to the lower courts bill, Honorable Horn, indeed, there is a policy being developed on the judicial administration model, which impacts on the development of the lower courts bill and the magistrates bill. You will remember that the former Chief Justice started a process with regards to this issue. So we will take it from that context, dealing with the single judiciary in that regard. So that is what has impacted this matter, but we'll be able to give a clear outcome when we have dealt with it. And I can confirm to the honorable members that from our side as the executive, research has now been concluded with regards to what the judiciary has raised with regards to the court administration. And we are now ready to engage with the judiciary on what we believe should be the court administration model of our country, but also to engage with the members of the public and society at large, because we believe this is a matter of public interest. So society must also come into the space and play their role. With regards to the CRT contract, it was a long-term contract that was awarded through SITA. The advert for the new CRT long-term contract has already been closed, and SITA will begin the process to appoint the new contractor. The current contract has resolved more than 90% of the challenges relating to the contract. The other challenges are caused by load shedding. It's no longer the issue of a CRT. So it's a month-to-month type of a contract up until the new long-term contract has been appointed the honorable chairperson. So that is the matter that we are also dealing with. The issue of a transparent list on the court infrastructure. We are also engaging with the public works and from our side, but we do not think that the list should not be open. And if there's a question, we always answer to which infrastructure projects are struggling. And some of them, there is movement, honorable chairperson, like the magistrate court in Mamelodi. There is now some movement that we believe will finalize that court very soon, which was a very thorny issue even for the late member of this committee. And in her honor, we'll have to finalize that. And there are other infrastructure projects where there is some bit of movement, and where there are challenges, we continue to engage with the Department of Public Works. With regards to the online system, I think I've already spoken to that. The issue raised by Honorable Horn, I already spoke to that issue. The issue related to Steenhoff, I do believe that the NPA indeed will be able to explain this issue. Suffice to say that as per the last report, I was told that they are at an advanced stage of investigation, and also on whether to decide on what should be done with regards to the outcome of that investigation. But I do think that the NPA will be better placed to provide that report. And for us, it remains a matter of key strategic importance, because it's one of the biggest commercial white-collar crimes that has happened in the country. So it's a matter of priority, and the NPA will be able to unpack exactly where they are and what is happening. The IJS one I've already responded to. The ICC, I think the errors have been corrected from the presidency with regards to our position on the issue of the ICC. That what we are working on now is to look into how we have domesticated the Rome Statute. Other countries across the globe, including the Great Britain, Holland, they have domesticated it in a manner that the executive, because it's a policy-centric and diplomatic matters space, has got powers to exit or to suspend the operations of the statutes if it is not in the national interest to implement such a statute. But how we have domesticated it here in our country does not give us that kind of a space. With regards to the issue raised by many members on the comparison with Palestine and Russia, it's not me, Chairperson. This has been observed by the Amnesty International about the double standards by the ICC in terms of when it opens investigations and referrals of matters. And this Palestine example and Ukraine is not the only one. There are also other matters that are still not yet finalized, that have been sitting with the investigators of the International Criminal Court. And they cited issue of resources, including with the issue of Palestine. One of the issues that was cited was that, but these investigations were long opened before the Russian-Ukraine related investigation. So the point we are raising is that the ICC must not have eyes when it comes to the law. It must be equal, it must be fair. Everyone must be treated with the same measure. So if with the Palestine issue, it was opened before, the ICC should have by now referred those atrocities and crimes against humanity that are happening in that area of Palestine, so committed by the Israeli authorities. So it should have been, by now, there should have been a decision to refer, because it happened long before this issue related to Ukraine. So that is the point. We are calling for fairness. And I do believe that even members in this committee, they also want to see fairness, that where law is applied, it must be applied fairly, equally, without any eyes across the globe. So that is has continuous to be the position of them of ourselves, and we continue to believe that the rule of law gets undermined when the law is applied selectively. So, Chairperson, I think I have answered or responded to some of the matters, and I hope that some of them that I might not have been able to respond to the departments as they go through will be able to deal with them one by one and with specifics. Thank you, Chairperson.
No, thank you very much, Minister. Just one or two questions on my side. One relates to this judiciary-led court administration model. You are saying that you are ready on your side to engage, and this issue has been outstanding for some time now. Do you perhaps have a project type, kind of when are you going to engage? Who are you going to engage first? How, in terms of your project, when do you think that this thing would be done, the engagements would be done? So that we get a sense, because since I joined the committee, I think we have been really struggling with this issue. So to just leave it at the fact that now you are ready to engage, I think we need much more details. For instance, when are you going to start? Who are you going to be engaging? When is it going to come to Parliament? And then if yes, possibly when?
Yeah, thank you very much, Chairperson. Indeed, we will. The first stakeholder we will engage is the judiciary, and then we will then take this to public engagement. And internally, the matter is undergoing the cabinet cycle. I'm hopeful that before the end of May, it will have been discussed by cabinet fully. But the aim of discussing it is to take the first bite by cabinet to give us some form of guidance and parameters of engagement with the judiciary, and also we will also find a way where the portfolio committee could also make its inputs, and also the stakeholders in the profession and society, and those that may want to make an input into the matter. Our time frame is that at least by October, we must have completed this type of engagement and then come up with a clear path in terms of a policy position, and if there's a need to amend any legislation. Before the end of this financial year, we must be able to come up and table if there is a need for any amendments of any legislation. So that is the time frame that we have put for ourselves. Thank you, Chairperson.
No, thank you very much, Minister. I think my last one, which is more of a suggestion to the committee. I always get somehow confused by the fact that the department would always tell us that they are briefing 83% previously disadvantaged communities. But when you go out there, nobody sees that 83%. Judges, president, they just do not see these people, most of them appearing in their courts. If you go to the JSC, there's a lot of anger and noise about the briefing patterns. Now, the issue would be, if indeed we are saying it's 83%, it's 83% of how many cases? And what is the quality of those briefs? I would suggest, members, that maybe in the next term, there is some focus by Parliament to understand this matter much more better than to just be dealing with statistics. But when we go to our constituencies or to any other forum other than Parliament, those statistics are highly disputed, that they are not the true reflection of what is happening on the ground. That we have a program when we come back after June to engage on this matter. Will that be in order, members?
Yes, Chair.
Thank you.
Chair, can I just raise an issue on that? It's Deputy Minister Jeffrey. On the department's website.
Yes, Chair.
Can you hear me?
Yes, we can hear you.
Yeah, on the department's website, there are details of the briefs. So I think the committee should also look at the website on a monthly basis. The last one was February 2023, which would have the number of briefs, and it actually details which advocates got the briefs. So that information is all out there. It's basically date on a month-by-month basis, divided into the state attorney's offices, a name of advocate, senior, junior, male, female, black, colored, white, Indian. Were they the client's choice? Were they from a briefing committee? Were they the attorney's choice or the MD's choice? Who was the state attorney dealing with the matter? Who was the client, which government department, and the nature of the matter? I would suggest, in support of what you're saying, that you though also do look at the department's website. Thanks, Chair.
Thank you very much, Deputy Minister. I think that would be helpful. We need all that information so that we can, Parliament can.
Chairperson?
Honorable Minister.
Yeah, I just wanted to add on what the DM has said, just a bit, that the total briefs, for example, in the last financial year were 6,075. The ones that have been issued to females is 2,525, which is 42% of the briefs. The total value of the brief was about 1.2 billion rands. And the total value that went to previously disadvantaged individuals is 1 billion rand and about 66 million rands, which is 86%. The total value that went to females is 366 million rands, so which is almost about 30% of the total number of briefs. So all in all, out of 6,075 briefs, 5,693 went to previously disadvantaged individuals. So I agree with the DM that all this is in the website, it's transparent, it's open. But I do think that the challenge which we face, particularly when you meet the profession and ourselves also meet the profession, is that if you look at our budget for the state attorney, it's almost R1 billion. And some of the state-owned entities, this is a budget of some of the state-owned entities. This is R1 billion only for the national departments and the provincial departments that the state attorney deals with. But they are state-owned entities that are doing work in the space. briefing, which then you don't have these stats. You cannot go, for example, into the website of ESCOM or Transnet and know who do they brief, how many PDIs and so forth. Same with local municipalities, and also same with the private sector. The JSE listed companies, it is given when they brief is clear. They only brief a particular raised group of wide practitioners or big law firms and so forth. So I do agree with your suggestion. It will unravel this to show that for us to achieve this transformative objective, we need not only the state, but all role players, including the private sector, NGOs and civil society to play their role. And ourselves, we're putting it on our website to provide leadership that everyone must make it open and transparent. And then hopefully it will influence others to do the same so that we can know and see how they are contributing to this. But lastly is that the measure that could also help us in terms of the yardsticks, in terms of everything, to know how and who did what in terms of the stats and the impact, is the legal sector code that we is currently in the process of getting those comments that the LPC and DTI are working on. Once the legal sector code is promulgated, it will also make the work of ourselves and the committee to track and trace this issue very easy. Thank you, Chairperson.
Thank you. Has the Minister of DTI signed the legal sector code?
No, not yet, Chairperson. I was informed by the Solicitor General that they've taken the comments to the Empowerment Committee of the LPC to attend to the comments. So after that, I think then the process of a finalization will then ensue.
Thank you very much, Minister. Thank you very much for the briefing. I think that brings us to the end of part A. Can we swiftly move to part B, which will be to invite the Office of the Chief Justice?
Chairperson, can I request to be excused to attend to other engagements?
Yes, I think you can.
Thank you, Chairperson.
Thank you very much.
Chair, can I also be excused? We usually let the Office of the Chief Justice do their own presentation.
Okay, no, that's fine.
May I also be a parrot, Chairperson, and ask that I be excused?
Hey, we can't excuse our traditional leaders. Only joking.
No, you are excused, Deputy Minister.
Thank you very much, Chair.
Thank you. Office of the Chief Justice, you have 30 minutes to present.
Thank you, Honorable Chairperson of the Portfolio Committee and the honorable members. I am with the Executive Committee of the OCJ, and with your permission, without wasting time, I will not do introductions. I'll ask the Head of Strategy and Reporting to do the presentations, after which I will follow and we will take questions. If I may, Chairperson.
Please proceed.
Mr. Malau, the Head of Strategy, will proceed. Itumele.
Presentation. Okay. Can I continue?
Itumele, proceed. We are losing minutes.
All right. Thank you, SG. Good morning, Honorable Chairperson, and morning to all the honorable members of the Portfolio Committee. Chairperson, our presentation for the day is structured as follows. Our structure is threefold. We've got part A, which will mainly focus on the overview of the presentation with emphasis on the purpose of the presentation. the introduction as well as the consultation that was undertaken in developing this plan. And part B will focus on the situation analysis, and the last part will focus on performance information or measuring performance, which basically we look at the 3 programs that are part of our budget program structure, and the next part will be the financial information and the updated risk, and then we'll conclude our presentation. Chairperson, we are here today to present and share with the Portfolio Committee our annual performance plan for the 2023-24, as well as the budget for the 2023-24 financial year. As part of the introduction, Chairperson, this APP that we are presenting this year is basically the 4th APP towards achieving the outcomes and the impact as outlined in our strategic plan. And this APP, Chairperson, has developed in line with all the relevant government prescripts as well as the frameworks, including the National Development Plan. Chairperson, in developing this plan, we engage extensively with various internal and external stakeholders who are very key in ensuring that our APP aligns and satisfies all government priorities. And some of those that we consulted with, Chairperson, are the Department of Women, Youth and Persons with Disabilities, the National Treasury, the Department of Planning, Monitoring and Evaluation. In terms of governance, we also conducted the Auditor General of South Africa, the Audit and Risk Committee, the OCJ Executive Committee was consulted, and the Operations Committee of the department was also consulted. And lastly, we had an engagement with the ministry last week, where we presented this particular plan. Moving to part B of our presentation, Chairperson, one of the key principles of planning requires that when you plan, you also scan the environment upon which you operate on. And by so doing, Chairperson, we evaluated the environment and we looked at various factors that could actually impact on the effective implementation of our strategy. And in looking at that particular environment, Chairperson, we identified both internal and external environment that can impact on our effective implementation of this plan. And in terms of external factors, Chairperson, we looked at political factors that could affect the OCJ and also access to justice. We also looked at the impact of the current status of the economy on access to justice, the social factors that influence the justice system, and also the environmental factors that may have an impact on the implementation of our plans. And in terms of internal factors, we looked at factors such as the capacity within the OCJ, whether the capacity that we have really supports our structure as well as our mandate. And we also looked at issues pertaining to fraud, or keeping fraud and corruption. Chairperson, we remain vigilant in terms of issues that may affect the institution, particularly on fraud and corruption. And as a result of that, we continue to put controls in place and, and measures in place to ensure that we kept any opportunity that is relating to fraud and corruption. The next issue, Chairperson, that we looked at in terms of our internal environment was the health and wellness programs. We believe that a healthy workforce, the workforce that will assist us in achieving, our deliverables. So as a result, Chairperson, we have decided to invest a lot also on health and wellness programs. ICT remain one of the business strategic.
Chairperson, sorry. Honorable Neo Drugan, sorry for interrupting to the presenter, but the presentation isn't moving along with the presenter. And then can you also put the presentation on slideshow, and it's also not moving. Sorry, Chair.
Chairperson, I will assisting.
Thank you, Honorable Neo Drugan. But please make sure that by the time the 30 minutes end, you are done. Because you focusing on the targets and other things.
All right.
Yeah, emailing us. I don't think you must read each and everything. Let's focus on the gist of the APP so that we can leave time for other comments.
Okay, noted, SG. Is it reflecting now? Can I proceed?
Slide number now.
I'm on slide.
This one.
Yeah,
Yes.
you've done slide 7. Let's move to slide 2, program 1.
Okay. Thank you, SG, and thank you, Chairperson. The next slide, Chairperson, will focus on the program performance information with the emphasis on program 1. The outcome for this particular program is effective and efficient administrative support. Chairperson, program 1 focuses mainly on matters relating to governance, modernization, and also outline equity indicators which are really geared towards improving the livelihood of women, youth, and people with disabilities. We also put under this program emphasis on our, in our plan on issues pertaining to keeping the fraud and corruption within the department. And to that effect, Chairperson, we also continue to enjoy 100% achievement of financial disclosures by all the SMS members and all other categories, like for instance, staff in our supply chain environment. And during this financial year, Chairperson, we will also continue to ensure that 75% of fraud cases are investigated within 60 working days. Another aspect that I want to highlight, Chairperson, is with regard to the 3 categories that I've already indicated, equity and equity indicators. For youth, Chairperson will ensure that at least 30% of our workforce comprises of youth, and we'll also ensure over the MTF that at least 50% of women, at least 50%, there's 50% representation of women at SMS level. And we'll also lastly, Chairperson, ensure that at least our vacancy rate is kept at a rate of 10% or lower. Chairperson, I'm going to move to program 2, which is our core business. And then program 2 mainly focuses on fraud administration. Or maybe, Chairperson, before I move to program 2, let me just indicate there's a slide on COVID-related matters. As the executive committee of this department, the decision was taken that when we were planning, I think around towards the end of last year, a decision was taken that given the global challenges still relating to COVID, it is important that we continue to retain for the final year all the indicators that are related to COVID, so that we continue to monitor any impact that relating to this pandemic. So we will continue for this financial year. It's the last financial year that we will have any related COVID indicators in our APP. Moving to program 2, Chairperson, the outcome for this program, I'm just going to highlight only the most important outputs. The first the outcome for this particular program is improved court efficiency. And we have got, in achieving that, we've got an output on default judgment. And our plan in the first year of the MTF is to ensure that at least 76% of default judgments are finalized by registrars within 14 days. And then 80% are finalized in the 2024-25 and 80% in the outer year. And the next one is the bills of cost finalized within 60 days. And our target in the first year of the MTF will be 85% and 90% in the second year of the MTF, and in the outer year, 90%. And the last one that I want to bring to attention of the committee on this particular program will be the warrant of release delivered within 1 day of release. And the commitment that we have made, Chairperson, is to ensure that at least 100% of warrant of release are delivered within 1 day of release being issued. Chairperson, I'm going to move to the last program, which is judicial education and support. And then the outcome for this particular program is enhanced judicial education. And the key output in support of this particular outcome is basically judicial education courses. And our commitment for the first year of the MTF, is to ensure that at least 115 judicial education courses are conducted, and then 120 in the second year of the MTF, and 125 in the third year of the MTF. And the next one on this, the next output in support of this particular outcome, Chairperson, is the indicator on research. And our commitment is to continue to produce 2 research monographs. And these research monographs are mainly geared towards assisting the improving our research material, as well as our education courses. So our commitment is to produce 2 research monographs over the NT year. The last 2 indicators under this program that I want to believe that will be of interest to the committee. The first one is the one on the GSC, Chairperson. Our commitment is to ensure that we produce 3 reports on judicial appointments and judicial complaints. And every year of the NTF, our target will be 3. And the last one will be on the judges' registrable interest. And our commitment is to ensure that at least 2 reports are produced on the status of disclosures for judges' registrable interest. Chairperson, the next slide again is mainly on the breakdown of the targets on quarterly basis, so I'm not going to go into that. Allow me at this point, Chairperson, just to hand over to the CFO, acting CFO, who will take the, the committee, who will take the committee through the financial information. Thank you for now, Chairperson.
Okay, thank you, Chairperson, and the honorable fellow committee members, and Mr. Mayor, thank you. I'll take over the financial matters. On the budget for 2023-24, we've got 2.29 billion, of which 1.34 billion is for voted funds, and then 112 is for direct charge, out of the National Revenue Fund for judges' remuneration. The program 1 budget is 271.42 million. The superior courts, that's where most of the budget is lying, is 979,782. The judicial education is 53 million. The challenge that we are going to have this financial year is under compensation. Official compensation previous year was 850 for voted, and then this financial year is going to be 822,974.93. The previous year's compensation for judiciary was 1.3 billion. Currently, is going to be 989. Through the COE committee, will ensure that we monitor budget since it has been reduced, especially under voted funds, to ensure that we capacitate the courts. And then on the goods and services, we have 372,119 million. Under transfers and subsidies, which mainly the funds for transfer and subsidies is for judges' gratuities, it's 136. And then under capital asset, it's 108,418 compared to last year, which was 138. The challenge under the capital asset, we're still having a challenge with CETA ICT procurement, but we believe we will ensure that we spend the funds this financial year and address the issue of CETA. Thank you, sir. That's the end of my presentation, Chair. Thank you.
Thank you, Acting CFO. Chairperson, the next slide will focus on the key risks. With your permission, Chairperson, I'm just going to highlight about just 2 key risks that we'll be focusing on. We've got the number of risks that are already outlined in our presentation. But in the interest of time, Chairperson, I will focus on the 2 ones that are key. The first one is around the procurement area, Chairperson, and one of the risks around that is basically the possible abuse of supply chain management systems. And in keeping the particular risk, Chairperson, we are going to mitigate it as follows. We are going to ensure that all members, who sit in the specification committee should be vetted before sitting on each committee, and the declaration of interest by SCM officials during the specification process will also be conducted. And the last one, Chairperson, will be the the prevalent fraud and corruption incidents, and we will ensure that we put controls in place to ensure that the OCJ kept any opportunity that is relating to fraud and corruption. Chairperson, allow me to stop there if it's all in order, and then that basically concludes our presentation. Thank you.
Thank you, Chairperson. I'm just going to add maybe few comments with the minutes that are left. But firstly, to highlight the emerging risks in terms of our environment, one of which I think the minister has already touched on. One of them is the main anchor of the emerging risk being the impact of load shedding. We are highlighting 3 areas with regard to those emerging risks, which is the Availability of power, which has impact, is a national issue, of course, that affects the entire country, but with the courts, superior courts that are affected. We have a complete list of all the superior court sites, as well as where the generators or solar or any other alternative way in terms of UPS to the extent available or possible to assist the courts to stay online. We can indicate that the Constitutional Court, as well as the Supreme Court of Appeal and the Free State High Court, are currently outside the load shedding schedule. And the other courts do have generators. We do have, I think, about 5 courts that still do not have generators, which we are dealing with the DPW and DOJ. Only one court has solar, which is the East London Court. With regard to water also is an issue, which also has an impact from load shedding. Of the 24 sites that we have, which inclusive of the national office in the Midrand, we have 19 which have backup water in place in the form of either the, we're talking to the water backup water system. 24 courts inclusive national office, 11 have either water tanks or boreholes, and 13 don't have any water backup measures in place, which we are looking at with regards to Public Works and Department of Justice. This is an emerging risk. The second emerging risk. The other emerging risk that we are looking at is the network availability. In terms of network downtime, I think we all are aware sometimes SITA is down, but also the load shedding affects the downtown in terms of the network availability. So the frequent system downtime is also an issue that we are looking at with regards to how to manage it with the SITA in that sense. Whilst we are on the risks, I would like to touch also on the issue of budget, just to highlight also the constraints with regard to budget. I'm aware that all departments are experiencing the same issues with regards to budgets and the cuts and the economic situation we are faced with. But it is important to highlight the fact that of the 2.429 billion of the current financial year that we have, 54% thereof is only for the vote, which is 1.3 billion, which leaves 46%, 1.1 billion for the direct charge, which is salaries of judges. And this 1.3 billion, which is for the vote, program 2 and 3 takes the bigger chunk. Program 2B, where the superior courts are, takes 75% of the budget at 979.7 million. And the last program 3, 4%, which is 53.3 million. So 79% of the budget of the vote 1.3 goes to program 2 and 3, with program 1 only 21%. But when we split the 2.4 billion total budget, the COE takes 75% of the budget, which is 1.812 billion, meaning we are left with 617.9, or almost 617 million to run the entire operations of the court. So I think it is important to highlight the impact that this has on the operations of the department. As I've indicated, 75% of the 2.4 billion goes to COE, and only 25%, 617 million, is what we are left with to run the institution. We continue to try and strive to do reprioritization within, as the Treasury also is unable to continuously engage on the extension or increase of the budget, but it remains a risk for us, which also impact the human capital in that regard. I will go to the area relating to one in program 2, we have an indicator that relates to the finalized default judgments within 14 days. The members will note that we have been performing at 99%, and we have in the 22-23 dropped to the target to 76%. We have been operating at 85, sorry. And in that regard, the explanation that we want to offer is that we are aware that we have to stick to the baselines and increase. But as I've highlighted, the impact of the budget on us and human capacity, as well as the COE ceiling, which we have to continuously sit on. I think the CFO can also indicate that at some point our COE numbers were going down, less than what we have in the establishment. But back to the issue, the reason why we have 76, which might be seen to be out of line with the baselines, is because we are experiencing a lot of resignations of registrars in the courts, in the superior courts. About 15 we have lost already as we speak. And therefore that places pressure on the existing staff that we have of registrars. The second point being that in the past, the National Credit Act default judgments were done by the courts, which is the judges. Now, subsequent to the Mpumalanga High Court ruling of March 22, that the default judgments be dealt by the registrars, that increases their workload. I anticipate that we'll be able to do an adjustment of these target in the next cycle or next year, once we have been able to determine the impact of what the National Credit Act default judgments will have on the dwindling registrar's capacity in the courts. The other aspect I wanted to deal with relates to 1 minute. Relates to taxations, the output or indicator relating to taxations. Also, we have dropped the baseline, the target, for this year, as opposed to 99 consistent performance in the baselines in the audited previous years. And also it's for the same reason, because of the staff turnover, that we are saying that we would rather have the capacity adjusted.
Sorry, SJ, there is somebody standing here. Can you mute yourself? Thank you. You can proceed.
Thank you, sir. I was just talking on the taxations, as to say, for the same reason that the target for this year is 80% opposed to the 99% performance, because of the fact that we are losing registrars who are experienced in the high courts, and we are looking at how we will be able to deal with. The other aspect that I wanted to comment on, was with still a few minutes, relates to the court online, the 5/7/11 MTF figures for the rollout. Just to indicate that we have the 5 courts is Gauteng, Joburg and Pretoria, the Concord, the SCA and Kimberley, which are looked at to be added in the current financial year. Obviously, we are subject to the consultations and approval with the heads of courts and the Chief Justice, who will have to be engaged in view of the issues around the case line part of the court online. Having said that, Chairperson and honorable members, maybe allow me to touch on the court online, as well as the case line part of the court online. IJS continues to support us on the court online system. And I would like to maybe make comments, with your permission, maybe Chairperson, let me find out if I may give certain information relating to the Thomson Reuters, as well as the other contracts that were in the issue, so that I don't conflate issues between the APP and the comments that I would like to make. May I get your guidance, Chair?
You can proceed. You still have 5 minutes. SJ?
Sorry, Chair. Am I audible?
Yes, you're audible. I said you can proceed. You still have 5 minutes.
Okay, thank you, sir. I just wanted to mention that the court online system, which we have developed together with CITA, part of which is the case lines which we have issues with, Just to mention that the total number of cases that we have in the court online system is now coming closer to 100,000, which is 99.6,000, and the bulk of which, of course, is in the two courts for Johannesburg and Pretoria, which is the Gauteng division. And we have a lot of, we can report that we have a total number of enrolled cases before a judge going to close to 21,000. Default judgment in the system, we have 7.7 thousand. And those that are enrolled before a judge, those who are for the registrars before the judge is 6.8 thousand. So we have also a number of users that have already registered on the system, 8.8 thousand also on the portal, which are the firms that are registered on the system. And we have a total number of judiciary users, which is the court users, sorry, which is judges and staff, 446. I'm raising this issue because I would like just to touch on the court online and the other issues that affects it. Just to highlight to the chairperson and portfolio committee members that I am still to brief the minister on the matters relating to the contracts, as well as the issues that befallen the case lines contract with regard to the investigation. The investigation, forensic investigation with the help of the SIU has been concluded on the 15th of March 2023. And we are grateful for the SIU assistance because we have only three members in the forensic unit at DD level and ASD level and level 7 who are part of the forensic unit, which is part of the human capacity constraints we have. We are grateful for the assistance. I just also want to mention that the public protector did indicate that they're investigating the matter, and they have also concluded on the 15th of March 2023 that they finalized their investigations with us, and they have indicated that they are not taking the matter any further. I also want to highlight the fact that having opened the PRECA, in terms of PRECA, the criminal case with the DPCI investigation, is ongoing, and I think I'll leave it to the DPCI to indicate how far they are with the case. But we are working closely with them, and I'm aware that the company Thomson Reuters is also cooperating with them on the criminal investigation with regards to this contract. On the civil side of things of this contract on the case lines, our counsel, together with the Thomson Reuters counsels, have been in protracted engagement, which relates to two issues. One, which is the business continuity arrangements, as well as the review of the contract by the courts. Both issues will be placed before the courts as per agreement between the two parties. As I've indicated, I'm still to brief the minister on these issues out of the forensic investigation issues, as well as the court cases, criminal and civil. And these two items of the business continuity and contract review of the case lines contract is ready. Our counsel and the counsel of the service provider, Thomson Reuters, have concluded, and we have already finalized from our side. Our senior counsel have finalized the founding affidavit as well as the notice of motion, which we are going to proceed to launch in the courts by the end of this week. After my final engagement with senior counsel, we are going to launch the case now before the courts to deal with the business continuity and the contract review in one application, having concluded the negotiations and the engagements between the two parties, which took quite a long time. And as I've said, I will be briefing the minister. The intention is also to ensure that we pilot case lines because SCA and Concord also needs the solution, as well as in Kimberley, which is the 5 courts plus Gauteng, as I've already indicated. Yes, I think I've already indicated that the OCJ and the service provider on case lines are cooperating on the new contract, and we are going to be launching the case as soon as myself and the council have engaged by Friday this week. The CRM dynamics part of the court online, as already indicated, I think when I do proper briefing, I'll break down what the court online composed of, which has 3 parts, which is the CRM dynamics, which is the case management side of the staff, and the case lines, which is the evidence management and the portal, which is where the public engages with the system from outside. The CRM Dynamics is done by Microsoft, and we are busy with CETA. We've been going into long engagement with CETA with regards to also ensuring that we comply with the CETA Act, firstly, secondly, going forward, and secondly, on the options with regards to business continuity. And we have agreed with CETA that the best way is to go the route of the court case that we are going to launch that I've referred to before. We have also on the other contracts on the ICT PKC, the urgent application that was launched against us to payment, the court ruled in our favor. We have lodged our counter application to review the contract, which the courts are still to hear it. And we have asked the SIU for proclamation, presidential proclamation on the other contracts with regard to PKC. And we sent that to the SIU in October 2022, and we continue to cooperate with them on the process with regards to that. I felt, Chairperson, honorable members, that I should make these comments, but I will still have to take the minister first. Thank you very much.
Thank you. Thank you very much. Members, any questions or comments? Honorable Jelle, Honorable Nieuwhout-Duchend, Honorable Horn, Honorable Breitenbach, and Honorable Janji, in that order. Honorable Jelle.
Thank you very much, Chair. And also, let me thank SG and the team. I only have some few questions, Chair, just to forward to SG. And let me just welcome the presentation, but also, Chair, note the issues that are brought to the Office of the Chief Justice when it comes to the issues of budget constraints. But I have this question, Chair. I want to find out from the SG, what are they doing with the, because I'm just raising some of the issues that we came across when we were doing a tour. On the issue of libraries, what are they doing in order to assist in terms of updating that material in the libraries? Because it seems as if there are problems that are coming with that issue, Chair. And then also on the issue of how are they going to assist on the issues of infrastructure, the problems that are experienced by the high courts in particular, Chair. Because all these plans that they have, if they don't have infrastructure to make sure that they take care of the materials, and especially the files, Chair, on the issues of files and issues of leaks in these courts, and the files that are everywhere in those high courts. Chair, I want to hear the view of the SG in terms of how are they going to deal with that one. But also, Chair, I have one issue on the issue of, there are issues that are came out and continually coming out from the JSC interviews, Chair, the concerns that are coming out when it comes to the issues of the judgment by the acting judges. I think the SG would have heard about that also, that there is a serious concern on the information that is coming when these interviews are conducted, which impact on the trainings that they do to the judges. I think I need to get more information on the issues of these trainings, Chair. The committee would like to hear that one. Lastly, Chair, on the issue, without touching on the rights and the rights of the judges, I heard about the issue of the disclosure of the judges. I just want SG to elaborate more on this one because I didn't get it properly when they were giving more explanation. Thank you, Chair.
Thank you very much. Members, also bear in mind that we will be meeting with the Chief Justice on Friday. So there are questions that we should be raising with the judiciary themselves, the Chief Justice, rather than the administration. So as we ask questions, we should bear in mind that there is that pending meeting with the Chief Justice. Thank you very much, Honorable Jale. Honorable Lebo Trochen.
Thank you very much, Chairperson, and good morning to everyone on the platform. Good morning to members of the Office of the Chief Justice, and thank you for your presentation. I would like to add to what Honorable Jale has just raised in terms of the libraries and the leaks. I'm also quite concerned about the lighting within the courtrooms. The lighting was very bad, poor lighting, very dim, and one of the judges said that he has to use his own cell phone as a light in order to read documents in his own courtroom. So one of our members who was with us counted the number of light bulbs that were not working. And so if we can't deal with these small little issues, I'm wondering and concerned as to how do we deal with the big issues. So I would like to ask for an update with regards to the lighting, not just the lighting, but the signage for women's toilets, because I struggled to find where the women's toilet is. I had to ask the staff for assistance for them to guide me to where the female toilets were. And that, you know, it was literally in a closet, almost like in a cleaner's closet. And that is not nice for the staff to work there, especially in a judicial environment. So I'd like to get an update on that. And then secondly, you spoke about the high turnover of staff. That is a concern. And so I would like to request an update on the plans for human resources for recruitment, if you could provide an update on that. And then I see the different courts getting renovations, and I saw comments on that. There was no mention about Malmesbury Court, the one that burned down. I see that there's no update in the presentation. My constituency office went to go and check at that, you know, at the site, and there's nothing happening there. So I'd like to request an update from you about plans for the Malmesbury Court. In your report, I just need to check your full report on 6.2.4. The OCJ could not achieve the full implementation of the planned rollout of the court online system. You spoke a little bit about that, yes, but I would like to get a full update about what are you planning to do about it to achieve that full implementation. And those are my questions for now. Thank you very much, Chair.
Thank you very much, Honorable Juan.
Thank you, Chair, and thank you for the presentation. Chair, let me, in terms of my first question, add on to what the Honourable Niva Drachen has just now asked, and that is in respect of the planned rollout. The SG has identified, amongst other, the Northern Cape High Court as a court where the rollout is to take place this year. However, when we were there on our oversight visit, we were informed by the local role players there that they've already been informed by the Office of the Chief Justice that the rollout will not happen this year because of the impact of the litigation and the ongoing investigations. So I don't know whether there is a gap in communication, but it is a bit of a worry that on the one hand, the APP and the SG, by way of the oral presentation today, keep on saying that this is what is planned, and on the other hand, local stakeholders and role players seems to have other information. And it's specifically, I might add, more of a worry in light of the fact of the assurances during previous meetings that the investigation and the litigation will not hamper a rollout and the full introduction of the court online system. So I think the pertinent question is this: has locals been informed, as they claim, that this will not happen this year, at least in the Northern Cape? Then, Chair, the only other issue I wanted to raise is in respect of the presentation, and specifically slide 31 there, around the potential risks and the threat posed by cybercrime in respect of our courts and online, let's say, communication and systems of our courts. And the worry is that this risk is let's say, a repeat risk in terms of identification of the risk, as well as the mitigation factors. So I would want to request through you, Chair, an update as to what mitigation steps and protective measures has been taken since this risk was first identified, as far back as I believe 2-3 years ago already, and to what extent is it kept here, because it is of course not going away. So in essence the question is, to what extent has internal steps been taken to fortify the systems of the Office of the Chief Justice against cybercrime, and to what extent does this remain a project that must still be implemented? Thank you.
Thank you very much. Honorable Breitenbach.
Thank you, Honorable Chair. I'm largely covered by my colleagues, and I'll save the rest of my questions for our interaction on Friday. Thank you.
Okay, thank you very much, Honorable Janche. Honorable Janche.
Thank you, Chair. Just a few issues, Chair, to raise. Maybe first to thank the SG for being very good in packaging what I call the 3 converging problems, especially in lower courts, which is electricity, water, and the networking issues as part of the risk that they have identified. And I hope that it's not just talk and ticking the box. One would have gone through the risk that they have identified, because, Chair, at this stage, as we would have been consistent about this, is that risk and their mitigation have become firmly a second twin on project management. It's no longer enough for people to say this is what we're planning and not even indicate how they are going to manage these issues of risk. The concern I have, which I think we'll also raise on Friday, was our Friday agenda with the Chief Justice, as you've indicated, seems to be attending to all issues, all levels of courts, because both the Minister and the SG they seem to know only the Concord, SCA, and Superior Courts. And there seems to be a gap about what happens in the lower courts. And unfortunately, I live in that space. I'm deployed in that space. My interest is in the lower courts. For both of them, there doesn't seem to be any risk measures in relation to the lower courts, and it has become an orphan at this stage. And yet on Friday, we're going to be raising such issues with the Chief Justice. I'm looking forward to the Department of Justice in terms of what they need to tell us about that, because for as long as we don't attend to that, many of these issues start in lower court even before they go to the other courts. And secondly, perhaps if she can indicate what she has identified this high turnover of registrars, and even mentioned a number about 11 that are just leaving. I'm interested in now that we are in a planning process, whether they've identified and packaged a process of how they are going to mitigate this, because the registrars are very critical in the functioning of court and administration of justice. I would want to hear how they want to deal with that. But I have to register, Chair, my having clapped hands for her for putting those three risks together, my disappointment about it doesn't go very far in attending to the chain of court administration or the administration of justice in relation to the issues of the lower court. And may I, as I end, Chair, which is not necessarily to OCJ, I see even the staff of correctional services are also not here, but we're going to be meeting with them to just indicate, Chair, that I hope that when we meet with them, they'll be ready to tell us how they are packaging the risk now that they have finally come to realize that it's not even breaking news what the minister told us about the intention to terminate. It's kind of long overdue and there's been an existing problem. I hope that when we meet with them, they're going to give us a risk management approach about what they're going to do, having now that they are going to be taking over. Just wanted to make those few comments, Chair. Thank you.
No, thank you very much, Honorable Janji. Over to you, SG.
Thank you, Honorable Chairperson. Myself and the team will respond to the issues. With your permission, maybe I could leave the questions relating to the Chief Justice, but just to mention in passing on the disclosure of registrable interest for judges, the OCJ is the registrar appointed by the minister to manage the disclosure in terms of the JSC Act. And the last, I think the CJ will also convey that the last disclosure status was that it was 100% achievement in that all of them disclosed by the end of March as prescribed. On the JS interview and acting judges concerned in terms of training, I will ask Dr. Musheu, the DDG in Sajay, to respond.
Thank you, SG. In response to that question, Sajay has started to engage judges president to initiate training in the divisions of aspiring judges to address the challenge that we've identified. Thank you.
Can you proceed, SG?
Thank you, Chairperson. On the issue of the Northern Cape and the communication gap by Honorable Kron, I think it's a misunderstanding probably, or how the message was conveyed to the committee. The court was informed that the rollout will not happen before March 2023. not that it will not happen in the current financial year. As soon as the courts has sanctioned what the interim arrangements should be, we are going to proceed with the rollout to the sites as already indicated. Obviously, each site is checked in terms of its state of readiness with regard to what must be in place to ensure that the rollout take place. With regards to cyber risk and the update on mitigation steps, I can mention that the CIO of the OCJ has been in touch with SITA to ensure that our vulnerability assessment is also made, which has been done, and we are managing the cyber risk continuously. We are not removing it out of our plans because it is something that is real in the world we live in today. We have implemented antivirus solution, firewalls, and as I've indicated, SITA has already done vulnerability assessment and remediations are being done. We have procurement of the threat and vulnerability solutions, which have been in hold because of the contractual issues that I already mentioned earlier. But other than that, we are working with SITA to ensure that our system is protected, and the CRO is continuously in work with them on that side. On not achieving the full court online system and the full update, may I respond to indicate that the court online, as it composed 3 parts, as I've alluded to before. The reason why we did not achieve is that one part of it is that we are consulting the judiciary as they define the needs of the system themselves. But on the other side, it is because of the review of the contract on case line, which is one of the 3 parts of the court online solution total. So as soon as that is done, we will be moving with speed with regards to the rollout, dependent on the court outcome. There was a question on Malmesbury Court update, renovations, as well as the Honorable Judge's comments on us not mentioning the magistrates' courts. I'm not in a position to speak for the minister. That was relating to the power, water, and network risks. I may not be able to speak on behalf of the minister, but the OCJ is not responsible for the infrastructure in the magistrates' courts. It is for that reason that I am unable to comment on that. However, with regards to the power, water, and the networks, I do have a list of all the 24 sites that I've referred to when it comes to electricity, which indicates which court has got the generator. As already indicated, only East London has got the solar. All the other courts have got the generators, and the capacity of each generator is indicated, as well as the status of each generator. Bearing in mind that some of these generators, when they were procured and installed previously, they were not geared for the power. They were just, they were not geared for load shedding complications that have befallen the systems in the entire country. Therefore, some of them require upgrade, some of them required replacement, but it is the project that we are busy with DOJ as well as Public Works to deal with that. We can provide the committee with a list of each and every area in terms of where the generator is present or absent, and what is the status with regards to each site. As already indicated, only 6 sites does not have, which we are looking at as part of the DPW program, because they are responsible for that. Water, the same comments with regard to water tanks and boreholes. The easier being the water tanks, we are busy with that with Public Works. We can also give a detail of the list to indicate which ones do have and which ones do not have water backup system. And mainly our concern is with regards to the new courts in Mpumalanga and Polokwane, which we are aware has been struggling, though they are new courts. So Public Works and ourselves and DOJ are working on that. And we have raised the matter. We have details on how we have dealt with this matter with the Public Works, raising and locking the calls with them to be able to respond to those issues. The other issues was the other issue was on the staff turnover, which is high. in terms of recruitment. Yes, we are experiencing that in the registrars generally, but we are putting measures in place. What we do from time to time is to ensure that as and when positions becomes vacant, we either use the mechanism of contract appointments to immediately fill the gap, but also make sure that we look at attracting the skills from outside to replace that, which sometimes is very difficult because the OSD is also part of what we are using in the registrar's office. And I agree that it is an area which closely supports the judges in that respect. We are also looking at mentoring as part of the strategy to also upskill those who are already inside to make sure that they are able to perform as and when the position becomes vacant. But however, we are managing the turnover with regards to generally in the department, in the OCJ, to make sure that there is replacement as and when the gaps occurs. There was an issue around library services and the materials that are not being updated in the course. The matter, we are aware of this matter. I'll ask the head of court administration to respond to this matter, Advocate Potgieter, with regard to updating of these materials. And as we would know, the library service is a shared service with justice, and the contracts are on the side of justice. We are not abdicating, but we have to ensure that the judges on their side have the material available. There is also in place a committee of judges led by, I think it's Judge Musi now, it was led by JP Leo in the past, who are also looking at measures because justice had raised the fact that the money for the libraries is too high, and therefore concessions had to be made in terms of which materials are going to be cut and rely more on the online virtual library and which ones will be used as the hard copies in the chambers and the libraries of the courts. So having said that, Chair, I just want to allay the Honorable Committee's fears that we are not doing that. Judges have, through their committee, expressed themselves on how best, given the resource constraint, which publications must be cut and which publications can continue to be updated in the physical form without relying on because they are also available in the virtual library sites. Advocate Potgieter, if you can proceed on that.
Thank you, Esty. You've touched on the important issues. Honorable members, Chairperson, good morning. Yes, the libraries is a shared service by DOJ, and we engage them frequently. But we're quite dependent on their guidance. However, we have established communication lines, and I will personally monitor the libraries and the update of research work in our libraries on a quarterly basis. Thank you, Esty.
On the infrastructure in the high courts and the files, as well as the leaks and some various problems have been mentioned around the infrastructure in the courts. Maybe just to mention that is also a committee led by a judge of the JP Mlambo that also looks at the infrastructure in the courts, which includes also the magistrates' courts. I may also maybe profile chairperson to say maybe the committee, when it meets with the Chief Justice, can also raise the matter. Besides the fact that we go through Justice Department as well as Public Works, we are aware of the issues, and the heads of courts has also expressed itself on the difficulties around the courts and asked for a priority list in terms of when will the areas that are problematic be prioritized in terms of addressing them. However, there is also through the NEEC and the PEECs led by the Chief Justice at national as well as the judge presidents at the provincial level, where also Public Works is accounting to and providing reports on the plans with regards to addressing infrastructure issues in each court. Also at National Office, we are in charge with National Department of Public Works to ensure that some of these things are dealt with and raised. We are aware of the lifts, aware of the, I think what has been raised was also the lighting in the courtrooms, which are mainly because of the old infrastructure or architecture of the courts with the wooden and the lights that are inside the courtrooms. We will, I assume that the question was related to the Pretoria local division, main division of the Gauteng. We are aware of those and we are working with Public Works on those, as well as the leaks. But I wanted to touch on the issue of the files that we have developed already a business case with regards to digitization of court files. It is a national problem. National archives are full and we do not have the space. So we have latched on the contract with DOJ, and we are having a business case which we are to discuss with the IJS to see how they can assist us to deal with digitization. We have looked at other departments and what they are doing, like Health and Stats SA, which are very good with regards to managing and digitizing records of the state. So we are looking at those options and we will be able to indicate how far have we gone with digitization in that regard. The issue on the signage for women in the toilets in Pretoria, I assume I will look at it and provide the feedback to the committee as soon as I have the facts around it. I think I've covered all of the issues, Honorable Chairperson and members. If not, I'm in your hands. Thank you very much.
Thank you. Honorable Neville. Was that an old hand or a new hand?
Yes, thanks, Chair. Now, Chairperson, I just wanted to point out that the lighting and the signage wasn't only, it wasn't at the Magistrate Court, it was at the High Court, yes. And then secondly, the library issues, it wasn't just the updating, but it's also the books and things that are on the floor. So that are not on shelves, which I was also worried about, taking care of our old resources, our old books in the libraries itself as well. Thank you, Chair.
Thank you very much. Honorable Janji, your hand was up at some point. Was it an old hand or a new hand?
It was the legacy, Chair. My apology.
Thank you very much. Over to you, SJ.
Yes, Chairperson, I have noted the library issue, and obviously one will have to check why the books were on the floor. It could have been that it was time for asset register verifications, which normally takes place twice in a year. So I'm not offering it as an explanation. I'll still have to get the facts why the books were on the floor. But on the other matters, I've already commented on that. And I note the last honorable member's comments on the signages and the books and the library services. Sorry. Thank you, Chair.
Thank you. Thank you very much. Members, are all your questions answered? I think so. That brings us to the end of the meeting. We will meet tomorrow at 9:30. Is it 9 or 9:30? When?
According to my program, it's 9.
9 o'clock, yes. Then we are supposed to have 2 meetings, one at 9 until lunchtime, and then another one starting at 3, but we are still awaiting for approval for the 3 o'clock meeting. But thank you very much to the Office of the Office of the Chief Justice, led by the Secretary General. Thank you to all members and everybody on the virtual platform. Thank you for your kind attendance. The meeting is adjourned.